I rise with some trepidation, but and actually also with an open mind, because I want to get some clarity on just one or two of the amendments. In general, the group of amendments that we're discussing here seem eminently sensible in terms of safeguarding, but just a clarification. Maybe Baroness Chakrabarti could give me some help, because I thought her explanation was very well made and detailed and useful and explained the two different groups. My concern is specifically with Amendment 82, which effectively says that anyone who is a victim of criminal conduct within Section 1 cannot be considered by the family court to be a potential perpetrator of parental alienation. And that seems to me to be an extraordinary thing to put into the law, to say that somebody cannot ever be considered by the family court to be a potential perpetrator of anything, would seem to go against the spirit of open inquiry, the possibility, for example, that even if one is a victim, that you might well indulge in something that was not savoury or that you disagree with. We actually, in the previous group, heard a huge amount of about the damage that can be caused by false allegations, and I think that we have to always consider that there is a possibility that false allegations are used to alienate one parent against another. It's become known as parental alienation, and I'm rather sympathetic to the Noble Baroness Baroness Chakrabarti's concern about medicalisation. I particularly don't like quack medicalisation, and I'm glad to hear so many noble lords are worried about the fact that people who call themselves experts aren't necessarily experts, something I've been arguing for quite some time across a range of issues, so good on all that. But nonetheless, this Amendment 82 uses the term parental allegations and alienation, and therefore I want to know how this amendment will help, because I think that if anyone is using, for example, falsifications that are aimed at removing one parent from a child's life, even if that parent was previously guilty of a crime, we just have to be careful, do we not? I think we know that creating false narratives by telling a child or distorting information about a parent is not going to be in the best interests of the parent. And I might even understand why somebody who is a victim of domestic abuse in any context will feel incredibly bitter and hostile to the parent. But I think that we have to let the court decide rather than putting this into the law. Sorry, I've just lost my place there. I was struck when I was reading the briefings for this, related to this group of amendments, how often use of the term pro-contact culture was used. I am, generally speaking, pro-contact culture, I think, because I would want to be in a situation, apart from in the instances which actually have been well laid out in the other amendments, that the presumption is that the best interest of the child is to have contact with both parents. And I don't necessarily think this is gendered, although I appreciate that obviously more women... No, I said that the other day in my amendments. I hope everyone accepted that more women are the victims of domestic violence, but it is also the case that it can work both ways. So I would like each allegation to be carefully examined by the courts. That's all that it needs to be, that, because we should have the aspiration that both parents should work to restructure the family in a healthy manner after separation, even after the massive disruption of domestic abuse. And I think that in the spirit of saying that also that people who commit certain crimes, I would want them to be rehabilitated, to become responsible citizens, and so on and so forth. I just don't want something that is so blanket as Amendment 82. Yeah.
To her. Her argument that she's just expounding now would be a case where a couple had separated. There may have been some domestic abuse, domestic violence, but she's saying actually they should both have the opportunity to try to get together and work things out for the sake of the children. And I don't believe there is anybody in your Lordship's house who would disagree with that sentiment. That's not what this amendment is trying to do. What it's trying to do is to say that when the charge of parental alienation is used, it's almost demonstrating, simply by using the terminology and everything that goes with it, that the battle by one party still continues against the victim. And therein lies the problem. The latter principle, absolutely fine, but that's not the way that the people who bring forward claims of parental alienation behave in the court system.
Well, my only final point was to say that the term parental alienation has become problematic on both sides, because it seems to me that one side can use the term parental alienation in the way that's been described, but it's a term that is being used, and I've made the point it's used in the amendment. Another side can basically say that anyone who uses the term parental alienation is actually on the side of, usually the accusation is that they don't understand the problems of victims of domestic violence. Usually it's said that they're on the side of men's rights campaigners. I'm not saying any of that. No. I was trying to get to on one amendment only of this very big group, I want some clarification, because I think it's unhelpful to put it onto the face of the law.
If I could just briefly respond to the noble lady, and I thank the noble lady Fox for her constructive engagement and everything she said. So I'd like to respond on that specific one amendment, and I understand where she's coming from. So what I was trying to, perhaps not put very well, but what I was trying to articulate before is that I fully accept as a fact of life, that marital breakdown will sadly, sometimes, maybe even often, create a rancour that can be passed on to the children, and the children can be caught in the middle, and they may feel that they're pulled in two directions, or perhaps one more than the other. It doesn't matter. That is a fact of life. That is a matter of evidence and facts. That is not, in my view, a matter for medical experts, but a matter, I think the noble lady is slightly sympathetic to this, but a matter for the judge to deal with and cope with. And in many cases, it will be about encouraging the parties to reflect on their actions, whatever their pain, reflect on their actions in the interests of the child. But it does not require the kinds of sums of money and the sorts of diagnoses that the noble lady Baroness Brinton was talking about, and it has to be said again to the committee that we're talking often about some very wealthy men. It's usually men, it need not be, but it's some very, very wealthy individuals who then pay some very expensive, slightly dodgy, well, if the noble Lord Russell can use the B word, I can say dodgy. They're paying some experts whose expertise I would query, but whose greed I would not query. And so here, when I'm talking about, and I can always reflect on drafting, that's what committee's about. But here, when we're talking about considered as a potential perpetrator of parental alienation, as opposed to, saying bad things to their kids about the other party, we're talking about this syndrome. That's what I was trying to reflect. They should not be diagnosed or considered for diagnosis for what was it, 90 days for this syndrome. Frankly, if they're a victim of abuse, it's almost inevitable that they're going to have some rancour or some anger, unless they're a saint, towards the other partner. And judges are well capable of considering that and then working out what to do on the facts. But it's really about attempting to separate facts from expert evidence, hard facts that judges can just deal with other court reports, and this so-called alienation expertise that's become a bit of a racket, some of us believe, and is being weaponised against victims. So if there's something in the clarity of the drafting that can be improved, that is the great benefit of committee. But I'm trying to respond with what the intention behind my amendment is, and I'm very grateful for the opportunity raised by the noble lady Fox for me to do that.